Other Legislation Amendment Bill 2025. The ART commenced operation in October 2024 in place of the Administrative Appeals Tribunal. The ART is responsible for reviewing administrative decisions made under various Commonwealth acts and instruments, including disputes ranging from visas, the NDIS, Centrelink and PPL, and workers' compensation. This bill amends the Administrative Review Tribunal Act 2024 and the Migration Act in efforts to increase the efficiency in the processing of visas. It does this in three ways. Firstly, it expands the circumstances in which the ART can make decisions based on the papers. Currently, most matters are dealt with through an oral hearing, with current circumstances for dispensing with the hearing limited to circumstances where both parties consent or where one party has failed to comply with requirements of the tribunal. Instead, this bill gives the tribunal discretion to dispense with a hearing when a hearing appears avoidable based on the facts of the case. Secondly, this bill amends the Migration Act such that the reviews of student visa claims must now be determined on the papers. And finally, the bill grants the Minister the ability to extend this provision to other temporary visas via regulations. I want to recognise that the ART is a really, really important institution in our democracy. This is the sort of last port of call for citizens where they feel that the government has let them down, has not served them according to the rules of government. So this is actually pretty fundamental to making sure that government is accountable, in this case accountable to individuals on individual cases. So it is important. I also want to acknowledge that speed of access to the ART and determinations from the ART is also critically important, because justice delayed is justice denied, and in some cases this can and truly have a significant effect on people's lives. So that's the context in which I approach these bills. And so I look at this and go, yes, I want to see the ART work more efficiently, because frankly some of the delays that I have heard in my electorate on people accessing and working within the ART are not acceptable in our community, and they have significant costs on the community. So I do agree that the ballooning, review decisions, particularly for student visa refusals, which now account for 40% of all lodgements, hold genuine reviews in limbos for months, often at great distress. I also acknowledge that the Nixon Review found that the system of review was being exploited by those looking to draw out and extend that process, again particularly focusing on student visas. For that reason, I do see good grounds for extending the discretion of the court to review cases on the papers, as in Schedule 1, and to dispense of oral hearing wherever possible. However, there are obvious concerns about mandating that type of visa class must be determined purely on the papers. As the Law Council of Australia argues, the blanket refusal of oral hearings for all cases represents a disproportionate response to the issue at hand. In the last 2 financial years, almost 50% of all study visa cancellations or refusals heard in the ART have been overturned, bringing serious doubt on the assumption that even student visas are clear-cut cases to be determined purely on written submissions. Which brings me to the second issue, and the one in which my amendment deals with. This is the ability of other visa classes to be captured in the future by this blanket rule simply by regulation. Well, it may be the case that many student visa cases can be suitably determined on the papers, although, as I have already pointed out, even this, I think, is questionable. Certain other temporary visa classes could also be problematic. The Law Council of Australia, while supporting the decision to exclude protection visas, argues that it is likely that vulnerable applicants would be captured by expanding these powers to other classes, including provisional partner visas, bridging visas and employer-sponsored visas. Quoting from the Law Council's submission to this bill, these decisions go to the core of how the tribunal operates for potentially wide groups of people and relates to its overall design, as determined by the Parliament only a year ago. Such decisions should not be left to delegated legislation. While I acknowledge that these regulations are disallowable for something so fundamental to the role of the ART, I would agree again with the Law Council, who argue that decisions that remove the ability of a whole class of individuals to have a hearing should, if included in legislation at all, be determined by Parliament under primary legislation. And so for these reasons, And I take the view of the Law Council very seriously in these matters, because this is about making sure, as I started at the start of my speech, that people can access justice where they believe that government has not served them as they should as an individual, whether they have been excluded on visas and whether they see that a decision by government is unjust. So this is a very, very important tribunal that we hear here. And so I do think there are some amendments that I urge the government to accept in this particular bill. The first amendment, made by the member for Warringah, will require these changes to be reviewed within 3 years, allowing the parliament to determine if there have indeed been unintended consequences. Again, a simple review after 3 years will make sure that we have accountability on these decisions. The second amendment, moved by the member for Curtin, will maintain some level of discretion within the tribunal to hold oral hearings for student and other temporary visa categories if they find sufficient reason to do so. Again, I think that is very practical and simple. The default will be towards determination on the papers. However, if it still allows the tribunal discretion, if they believe, if they find sufficient reason to have a hearing, which is also in person. And finally, my amendment would remove the minister's ability to expand this requirement to other temporary visa classes, instead needing a further changes to be made in the primary legislation as recommended by the Law Council of Australia. If the government were to accept the member for Curtin's amendment, I would see no reason to move my own. So, look, I want to conclude by saying no one disputes that lengthy delays in the tribunal process increase costs, reduce the effectiveness of our entire visa system and unnecessarily hold up genuine visa applicants. There is a cost, and a human cost as well as a financial cost, to the problems of this current system. But I strongly urge the government to consider the consequences of such blunt instruments and caution the government, or indeed future governments, from using the powers enabled in this bill to bring in other visa classes. I urge the government to accept the amendments made in good faith by members of the crossbench, I think in very moderate amendments that will, I think, add to the protections in the bill without taking away from the overall purpose and hopefully impact of the bill on people's processing times. Thank you.
The question is that the bill be now read a second time, and I give the call to the member for Menzies.
Thank